Justice Jacktone Ojwang, one of the dissenting voices in the September 1st Supreme Court ruling, said the decision of 4 of his colleagues relied heavily on a weak case presented to the court by NASA presidential candidate Raila Odinga. Justice Ojwang, in his judgment, questioned why the presidential election was under scrutiny only whilst 6 positions were contested in the general election on August the 8th.
And even if the court finds that irregularities were present, it may determine that the results ought to stand, since they were unlikely to have affected the results. End of quote.
Justice Ojwang and Justice Njoki Ndungu saying the rights of the voter who played a key role in the election vote were not taken into consideration.
The petitioner's case rests on just one dimension of the electoral process: electronic transmission of results. Moreover, the bulk of the assertions made as regards transmission is just that, contentions with only limited testimonial ingredient.
In her judgment, Lady Justice Njoki Ndungu would ask 3 key questions which, according to her, were not taken into consideration by her 4 colleagues when making their judgment.
Is the outcome incapable of being trusted to reflect the will of the people? 3. Can a reliable outcome be determined in a manner other than holding a fresh election?
While both judges say that the facts of the case were weak and baseless, Justice Njoki said that nowhere in the law does the electronic relaying of results bind the IEBC legally, and thus the case by the NASA coalition did not hold any water.
Our electoral process is not purely electronic. It comprises both manual and electronic components, and when the electronic component fails, the manual component kicks in. In my opinion, this is a rather ugly, grouchy, reluctant mongrel of 2 distinct processes. It's largely a manual system. That's what we have. It is distinct from electoral processes in countries like India, Australia, or the United States, where everything is electronic.
The judges share the position that the court should have resorted to verifying the Form 34As, that they were in custody of the Supreme Court. Leila Mohammed, NTV.